Okay, welcome everyone. We are going to start with question number 1. Here we go. And okay, Z owns and manages several homes that are rented. They have a real estate license, or he has a real estate license. Z decides to inactivate their license, what is true? Must they sell their properties? No. B, they must cease to manage the properties? No. And then C is the correct answer. They can continue to manage the properties they own. You can always manage your own properties. I mean, come on, okay? Even if you do have a license. You always have to let your broker know what you're doing, and you can't keep them in the dark of any issues or problems you may have, because that could come back and reflect on the company. I think as a broker, I've always required my agents, when they're managing your own rentals, to have a paragraph in the management contract, or not the management contract, but the rental agreement that the tenant signs that says that they acknowledge that you have a real estate license, but you're also the owner of the property, and our company, the real estate company, is not directly involved with the property management or any of the ownership of the property. So kind of, it's kind of an acknowledgement by the tenant that the broker has nothing to do with it. And that's just to protect the broker. Let's look at number 2, please. The correct answer to this one is they can continue to manage your property. They own it. I mean, use common sense. Okay, number 2, a real estate license is required if you are a salaried condominium manager employed by the association. No, that's one of the exemptions, actually. Be a regularly salaried employee of the owner who manages properties for multiple clients. Now, if you would stop right there where it said a registered salary employee of the owner who manages properties for that one owner, that would be fine. You wouldn't need a license. But if you're a regularly salaried employee of the owner, but you manage multiple clients, meaning multiple owners, then you'd have to have a real estate license, because you're working for more than one person. The timeshare people don't have to be licensed at all. They're only really just acknowledged. They pay $50 and they get a timeshare permit or license. Okay, so that's not the right answer. Regular salary employee of a property management company with the primary responsibility to manage accounts payable. That's an accounting job. I mean, you're just hired as a bookkeeper. Okay, so, but you are required. The B is the correct answer there. And the key there is they have multiple owners that they're actually working for. Let's look at number 3, please. E has managed the office building for his employer for 14 years as an unlicensed salaried employee. E's been asked to manage a fourplex in exchange for a percentage of the rents collected by a friend who is leaving the country for a couple of years. So E's considered taking on this additional project. The problem with this is that you're receiving a commission. You're getting a percentage of the rents. And whenever you have a situation like that, you need a license. Not only are you working for multiple owners, maybe in this case you may not, but it may just be one owner, but nevertheless, they would have to pay you by a fixed scheduled salary if you didn't have a license. But if you wanted to get a percentage of the rents, which would look a whole lot like a commission, then of course you'd have to have a license. So the correct answer to this one, number 3, is B. B must be licensed as a real estate agent in order to manage the fourplex. Number 4, please. P uses a quitclaim deed, okay, to give ownership to D. And now D's an owner, so he wanted D to sell the property for him. But since he's an owner, you'd think, well, maybe he could do that because he's an owner now. He's not just an agent. But he didn't have a real estate license in the beginning. And so what is true about this whole situation here? Well, it looks like it was contrived in order to allow someone who should get a license ownership so that they don't have to have a license. So even though you've jumped through a couple of hoops here to try to save the situation, it won't work. If there's a problem later down the road, the commission could just say, well, you just did that in order to, prevent you from actually acquiring a license that you should have. Because the correct answer to this number 4 is A. You could be fined for circumventing the license law. Your whole idea behind coming into ownership was not that you wanted to be an investor or that you want to stay with it for a while or whatever. They just were trying to find a loophole in the licensing law. And so it's kind of a substance over form argument. The IRS argues this a lot. Well, you got the right form, but the substance of this is that should have had a license. So and that's kind of what's happening here. B, P is exercising exemptions to the license law. Well, not really. You're kind of circumventing it in order that you can get around it. C, D can advertise the property through the Association of Realtors. No. And D, D says D can ask for a higher commission. Okay, well, whatever. Correct answer is A on this one. Look at number 5, please. Okay, a real estate license is not required for an attorney that sells real estate for a living. Yeah. If you're an attorney, that's one thing, that's great, but that doesn't exempt you from all license requirements. Someone acting as an agent. B, someone acting as an agent in a single transaction for a commission. I don't care if it's 1 deal or 20 deals, you need a license if you're trying to get a commission. Correct answer to number 5 is C, a trustee selling real estate under a trustee's deed, which would be a foreclosure. It's actually foreclosure of the deed of trust. And that is definitely one of the exemptions. Banks don't need to get a license every time they foreclose on a property and then resell it. And the answer D, a salaried property manager receives a leasing commission. If you get a leasing commission, you better have a license. Number 6. Which of the following have the authority to make rules for real estate agents? Okay, now who regulates you is really what they're saying, isn't it? And of course, the answer to that is A, the Real Estate Commission. It's the problem with the B here, the Division of Real Estate, is that they don't make the rules. The commissioners make the rules, and they hash them out, they write them down, they revise them, they send them over to the Attorney General's office, and they look them over and make sure their legalese and everything sounds right. Yeah, but the rules are made by the real estate commissioners, which is a cool thing because the commissioners, there's 5 of them, and 4 of them have real estate licenses, so mostly brokers, but sometimes we have sales agents and brokers on the commission, but mostly brokers. And then there's 1 that does not have a license, and they're called the commissioner at large, usually someone from an aligned industry, like a lender or a title person. Okay, but the division still doesn't make rules. It's just the commissioners, like I said. See, the Association of Realtors has nothing to do with the Real Estate Commission or the Division of Real Estate. Now, most people in the real estate industry trying to do it for a living, who are doing it for a living, are members of the Board of Realtors, primarily because they want to get access to the MLS. But the Association of Realtors is our private club. It has nothing to do with the regulators or state government. The Executive Director of the Department of Commerce. Well, okay, obviously that one's wrong too. Question number 7. Who's primarily responsible for enforcing the rules and statutes related to real estate transactions? Is it the AG's office? Is it the Attorney General? Well, they might step in and act as a lawyer, but it's not their primary responsibility. I mean, the AG's office has a lot to do and a lot of stuff that they have to worry about. It would be the Division of Real Estate, which is answer B. That's the correct answer. C, the Utah legislature. I mean, give me a break. I mean, they cover all kinds of issues, but that's not their primary responsibility. And the principal broker, it's not the principal broker's primary responsibility to enforce the rules and statutes of the real estate transactions either. It is B, the Division of Real Estate. Good one. Hope you all got that one. Number 8, the Board of Realtors differs from the real estate division in that the division A has regulatory authority. The Board of Realtors, like I said, is our private club. We have National Association of Realtors. We have state, the Utah Association of Realtors. And of course, we have local boards. You know, there's one up north. There's several up north. I mean, we have in Logan, and we have Ogden. You know, of course, you can go south. We have Utah Association of Realtors, Salt Lake Board of Realtors, you know, St. George Board of Realtors. Like I said, Dan and I are going down to work and teach and help agents that are part of the Iron County Board of Realtors. So, so that's state, local, and national. But the main difference is they don't have regulatory authority. I mean, they, you know, so yeah, we have code of ethics and things that we enforce against agents, but it's not, when you're talking about regulatory authority, you're talking about laws, rules, and statutes. And that's not what we have here. Number 9, a licensee has a maximum of 10 days to respond when? Well, their broker notifies them that the broker's license has expired. That would be not a good thing. No. B, they receive an offer for property they've listed? No. C, they are notified that their license has expired. Okay. No. It's D, when they receive notice from the Division of Real Estate about a complaint. This 10 days shows up quite a bit, but if you change your name, change your address, you change your affiliation with the broker, go with a different broker, you're convicted of a crime, then all these things you have to notify the division within 10 days. And of course, if they send out a complaint against you, you better respond within 10 days as well, okay? Number 10, the Division of Real Estate will look into commission disputes if licensing law was violated. That's A. That's warm and fuzzy. Hang on to that one because that's the right answer. Commissions are below this or above that. Come on, guys. I mean, obviously those are throwaways. It doesn't matter how much the commission is. You're either owed it or you're not for doing what you said you would do. But the division doesn't regulate the amount of commission. So both those could be thrown out because there is no state mandated percentage of commission. Commissions are all negotiable. And of course, D, the dispute is between a broker and your agent. That's something that the division will not look at unless there was a violation of license law or some dishonesty involved. So the correct answer to this one is A. Licensing law is violated. And if you if you stare at those long enough, you'll say, well, A has got to be the most serious thing up there, so that's got to be it. And you'd be right. Number 11, please. Which of the following penalties might the division impose if there's an illegal activity in the brokerage regarding the trust account? Well, what are they going to do if they find out there's illegal activity? We've seen some recently. We have one young man that was managing for his dad, who was the broker, managing the trust account, and he ran off with 200 grand. We have one office administrator who worked for a good close buddy broker friend of mine down south, and she ran off with $350,000. I mean, these things can happen. But number 11, what would the division do? A, jail time for the broker. Well, the division can't put you in jail. That has to be a judge in a court of law. So that one won't work. And then another one, B, this is a correct answer, by the way. They fine you and they issue a cease and desist order. They say, quit doing this heinous thing and we're going to fine you. My broker friend down south suffered a $5,000 penalty fine that he had to pay. I don't know what happened to the dad whose son ran off with $200,000. I still think that's being looked into. Really strange there. Let's look at number 12, please. Oh, wait a minute. They're not going to seize your brokerage assets. I mean, come on. They'd have to have a judge do something about that. And they're not going to give you community service. We do a lot of community service anyway. But that's something we like to do. Fish, Habitat for Humanity and all kinds of things that we work with at the board. Number 12. If an agent breaks a real estate rule or statute, who would they go before for hearing? Well, A, it's the commissioners. That's the correct answer. Now, their broker's going to get all upset, and also they're going to have to talk to their broker as well. But what we're talking about here is it's the commission. Even if the broker decided to let it slide, the commission probably wouldn't. And even if the broker fired the agent, there's still going to be a day of reckoning before the real estate commission. The director of the real estate division, they're an administrator. They're hired and could be fired by the governor. And of course, they run things. They're a regulator. They're a revenuer. Okay, but they're a regulator. Okay, and the Utah legislature, obviously, they're not even in session all the time. So that wouldn't be a good place to discipline agents. Number 13. When a licensee is found guilty of fraud, ooh, that's really serious. The real estate commission can impose A, fines and license revocation. That sounds pretty good. B, property seizure. Can the commission do that? We already had that just a moment ago. They can't come in and seize your property. The judge would have to do that. Jail time, judge would have to do that. Community service, well, probably a judge would order that too, but the commissioners can't do that. What they can do is A, which is correct answer, they can fine you and they can revoke your license. That's their extent of their jurisdiction. Number 14, please. Who may conduct an informal hearing? Informal hearings are pretty good. I mean, what's going to happen is the division staff member is going to look into this. It's probably going to be one of the investigators. And sometimes you can just stipulate to a small fine or more CE credit classes or something. But all this is going to have to be approved by the commissioners. But they could conduct the informal hearing. They would just have to take it back to the commissioners and see if they agreed or would come down with whatever sentencing after they have found out about all the facts. They're going to do fact finding. B, a broker who is not involved in the transaction. No. B, a broker or the agent involved. That's not really a hearing. That's a meeting with your broker to talk about what you've been doing, what you shouldn't have been doing. Okay. And D, an unlicensed neutral party. No. So correct answer to 14 is A, the division of real estate staff member could actually look into your situation. And that's probably where it's going to start. And what would be really cool is if you did something wrong, staff member said, yeah, this was wrong, but it's, it can happen and I can see why it happened and blah, blah, blah. And then you go back to the commissioners and the commissioners write you what's called a correction letter. Correction letter saying, this is wrong. What you did was technically wrong, but, we see that you discovered it and you made up for it. You did this and that. And so we want you to take some more CE credit classes and you have to do it by this date. Okay. Well, that's a gift from the real estate commissioner gods, because correction letters are not put in a newsletter. They're not made public. That would be good, because if you go before a real hearing and the commissioners come down and they attach fines and other penalties and whatnot against you, they could suspend your license. All that's going to be in the public record, and anyone that Googles your name is going to come up with that and know that you got some pretty serious trouble. It's not going to be good for your career. Number 15, please. Which of the following issues could probably be dealt with by an informal hearing? Okay, an action on a sales agent's license that would have been triggered by an adverse action with the sales agent's broker. That's a correct answer, by the way. Revocation of a license due to improper conduct. That's not informal hearing, that's formal. Revocation of a timeshare registration. Yeah, that's what the timeshare guys do. They register. That's formal. Cease and desist order, that's formal. The only thing that's not formal is action on a real estate license that has been triggered by an adverse action with the sales agent's broker. So in other words, the broker is disciplining you. I've had to do that from time to time, when I run offices, and that's been a lot of my career. I've run offices with as many as, well, I've had over 100 agents in some of my offices, and some of them I've kept small, maybe 8 to 12 agents only. But, I've had to discipline agents. I've cut them back on their commission 10% or something because they did something really stupid and they've done it more than once. And then I've fired them too. I sent them to work for a different broker. So all that can happen, but that's not like some of these other things that are, revocation of your license or cease and desist orders. Let's look at 16, please. The hearing will likely be closed to the public if the subject of the hearing includes A, a person's moral character. Okay, that's the correct answer. B, a financial dispute, contract dispute. Most of these hearing things are come up because of a poorly written contract and now it's disputed, or there's some sort of financial dispute between the buyer and the seller, and because it was also poorly written. I've had contracts come in written by agents that had 2 different sales prices on it, one in one place in the contract and one in another place. I said, what are you offering, this price or that price? Oh yeah, I made a mistake, didn't I? Yeah, well, we fixed it before we accepted it. And of course, D is financial complaints less than 1,000. No. Number 17, please. If a real estate license commits fraud, what can the real estate commission do? Well, they cannot do anything. The agent must be tried in a regular court. Now, that's not true. The commissioners can have a formal hearing and they can take action against your license. I mean, that's what they're there for. If you don't agree with what they did, you can take them to court, and they can argue it out in front of a judge. They can revoke their license and issue fines. So they definitely can do that. That's the correct answer here. C, they can revoke the license and sentence jail time. No, only a judge can put you in jail. D, they can suspend their license and seize their bank accounts. No, I don't think so. Okay, let's look at 18, please. If a licensee violates Utah license law, they may face fines up to 10 grand, fines up to 5 grand, fines up to 1,000, or fines for 3,000. Correct answer is B, $5,000 cap. But you see fines occasionally that are substantially higher than this. That's because there are different instances. So it's $5,000 per violation. If you've done 3 things wrong in one transaction, it could easily be 15 grand. I've seen 20,000. I've seen 5. I've seen recently, I saw the highest order from the division I've ever seen was in excess of $400,000. That was a real bad hair day for that broker. Okay. But it's $5,000 per violation. What they did in that case to ratchet that one up is they made him refund a bunch of commissions when he didn't really specify that he was entitled to a certain percentage or a plat fee or something. Since that contract was so vague in regards to the compensation, they ordered that he refund commissions for like 10 years on a number of different properties this particular broker was managing. That was totally devastating, anyway. Sad day. In other words, don't screw up. Appreciate you guys being here tonight. I know this is a little awkward. We're going to kind of cut it short tonight because it's not really working all that well. And Dan and I have to get back on the road to get down to Cedar City. Does anyone have any questions at this time that I can help you with? Anybody have comments or questions?
Do you recommend any websites where you can start taking practice, the test practice for the state?
Yes, we have a number of at the school. You can call in and talk to Dan or Matt, and they have a number of different practice questions that they can get you. If you bought one of the textbooks, we have a national textbook and a Utah law textbook. There's a number of practice questions in there as well. Yeah, you don't have to pay. Yeah, I mean, you have to buy a textbook if you want the textbook. But if you just want quiz questions to work with and whatnot, I would suggest getting hold of the school, and they'll get you some that you can work with. Great question. Anybody else have a question?
Thank you.
You're very welcome. Well,
I
thanks for being with
appreciate
us.
you guys.
Go ahead.
I appreciate you guys putting forth the extra effort tonight.
Oh, you're very welcome. And, you know, you're welcome to call us. I've had 3 calls this week already from different agents. 3 agents, they did a conference call with me. 3 of them are working on this property in Utah County. And this is the first time I've ever had this happen, but they wanted to know what their situation was because the seller of this property that they're working on, they brought some buyers over to look at the property, and they were all wearing turbans for their religious persuasion of one kind or another. Anyway, what happened was the seller said, I don't want to sell to those guys. They wear turbans. There's only one color you see when you're doing real estate, and that's green. Only one religion, it's green. That's all. I mean, so they want to know what their situation was if they had to go back and talk to their different clients. Yeah, I said, yeah, you can't hide this. I mean, you know, they either need to repent or you need to cancel the listing, period. You know, this is serious. You know, you don't discriminate people against national origin or religion. You just don't do that. That was one call. Another call with some questions about agency. I don't know why people have such a hard time with agency. It's not that tough. Come to my 12-hour class, my 12-hour new agent class, and you'll understand agency better than most agents that claim they have a license and do this for a living. But we've seen a lot of issues with agency lately. It's always been an issue, but it's just, you need to, I'm going down to Dan, I don't know which classes you're teaching. I didn't look at the roster, but I'll be doing the 12-hour new agent class down in Cedar. But I also do it in Salt Lake, usually about once a month or so. So just keep in touch. Anyway, appreciate you guys. Anyone else have any more questions? Oh yeah, you're welcome to call. Was a point of that discussion. Yes, calls. My number, 801-556-8000. That's 556-8000. Okay, and you've got the school numbers, and Dan gives you his number occasionally too. So yeah, we're happy to spend some time with you on the phone and help you any way that we can. And that extends not just until you get your license. I mean, come on, you know, I mean, you're our friends, our graduates. You know, we want to help you any way that we can. Thank you, Dan. Appreciate everyone tonight. And
Thanks, guys.
we'll see you again soon. Have a great October.
Have a safe trip.
Thank you. Goodbye.